All right, welcome everyone. As a future sports manager, probably the most important part of your job is protecting your number one asset, your athlete. And that protection, it really starts with mastering their image rights. So think of this as the essential legal playbook for your entire career.
So let's just jump right into a scenario you could easily face. Picture this, your star client's likeness, their face, maybe their signature move, it pops up in a brand new video game. The big problem? Nobody ever called you. Your client never got paid. So what's the move? Can they even do that? By the time we're done here, you're going to have a much clearer idea of how to handle that call.
Here's our game plan. We've broken this playbook down into 5 key sections. First, we'll cover the absolute basics of protecting an identity. Then we'll get into the 2 legal pillars, privacy versus publicity. From there, it's all about offense, how you sue. Then we'll call in the special teams, that's federal law. And finally, we'll look at the defense, because you always have to know what the other side is going to throw at you.
Okay, let's kick things off with Section 1, protecting an athlete's identity. Before you can even think about building a strategy, you've got to have the fundamentals down cold.
So, what in the world are image rights? Well, at its core, it's just the right to control how your own name and likeness are used. But here's what's so important for you to get. The courts define likeness really broadly. It is not just a photograph. It can be a nickname, a cartoon drawing, a look-alike actor, or even just a very distinct voice. We're talking about the entire persona.
So now that we've got that basic definition, let's look at the 2 legal pillars this whole idea is built on. That's the right of privacy and the right of publicity. And trust me, you absolutely have to know the difference between them.
Think of it this way. The right of privacy, over on the left, that's like your shield. It's a defensive tool. It protects any person, famous or not, from emotional distress. Like having their picture slapped on an ad without their permission. But the right of publicity, on the right, that's your sword. It's an offensive tool for public figures, like your athletes, to control and, more importantly, profit from the commercial value of who they are. One protects feelings, the other protects their wallet.
And this stuff didn't just appear out of nowhere. As you can see on this timeline, the right of privacy actually came first, established by a specific written law, a statute in New York. Then, a few decades later in 1953, a lawsuit over baseball cards officially gave us the right of publicity. Fast forward to today, and most states recognize both of these rights, either through their own statutes or through common law, which is just law that's been built up over years and years of court decisions.
All right, time to get into your offensive strategy. When your athlete's rights get trampled on, what's the play you're going to call? It's a lawsuit for something called misappropriation.
Now, to win one of these misappropriation cases under common law, you have to prove these 4 things, plain and simple. First, that the other party, the defendant, actually used your client's identity. Second, that this use gave them some kind of advantage, usually a financial one. Third, and this is a big one, that your client did not consent. And fourth, you have to show that this caused some kind of injury that could be lost income or even just damage to their reputation. You've got to prove all 4.
But it is not always a slam dunk. That very first step, proving they even used your client's identity, is often the biggest legal hurdle you'll face. Was that generic-looking quarterback in the video game really based on your guy, or was it just a coincidence? That single question is where these courtroom battles are so often won or lost.
And this isn't some fringe idea. The recognition of these rights is growing. Beyond just common law, 24 states have actually passed specific written laws to protect the right of publicity. And the 2 most important states for sports and entertainment law? Well, no surprise here, it's New York and California.
Okay, so sometimes state law just isn't going to cut it. That's when it's time to call in the special teams, federal law. This is where you get the more powerful, nationwide tools for your legal playbook.
The main weapon in your arsenal here is called the Lanham Act. For our purposes, its most important job is to prevent what's called false endorsement. This is when a company uses an athlete's identity in a way that could trick people into thinking the athlete actually sponsors or approves of their product, when they absolutely do not.
So, to decide if a false endorsement happened, courts use a test with multiple factors to see if consumers would be confused. They'll look at things like, how famous your athlete is, how similar the images used are, and this is a big one, if there's any evidence of actual confusion. Like, did people start asking if your client is the new face of some product? They even look at whether the company did it on purpose.
Another really powerful federal tool is the Copyright Act. Now, the key phrase to lock onto here is that it protects original works of authorship fixed in any tangible medium of expression. I know, that sounds a little dense, right? So what on earth does that mean for an athlete?
Well, the implications are just huge. It means that the person who creates the work, so the photographer who snaps the picture or the TV network that films the game, they own the copyright. They get to control how it's copied and passed around. This is a massive piece of leverage for athletes to control how their image is used in specific photos and videos.
But every good offense has to prepare for the defense it's going to face. And the main counterargument you are going to see time and time again is a really powerful one, the First Amendment, which, as you know, protects freedom of speech in the press.
So the first defensive play is called newsworthiness. If a newspaper uses a photo of Joe Montana celebrating a Super Bowl win to report on the game, that's almost always going to be okay. Why? Because they're reporting the news, and the First Amendment protects that, even if it means using an athlete's picture without getting their permission for that one article.
Next up is the incidental use exception. The classic case here involved Joe Namath. Sports Illustrated used a photo of him that had already been in the magazine, but they used it in an ad to sell subscriptions. The court said that was fine because the use was incidental to their main business, which was, being a magazine.
Then, of course, you have the parody defense. This one protects creative works that use an athlete's likeness to make a joke or some kind of social commentary. The key here is that the work isn't just a cheap copy. It's transformative. It's adding something new, like the funny satirical baseball cards in that cartoons case.
And that idea leads us right to the transformative use defense, which has become a major battleground, especially in these video game cases. The question the court has to answer is this: has the game developer significantly transformed the athlete's likeness into a new work of art, or do they just create a realistic digital puppet to make money without paying for it? That was the core issue in the big case against Electronic Arts.
Which brings us to the future. And really, a question for all of you. We've just gone through the entire legal playbook as it exists right now, but with the explosion of AI that can create unbelievably realistic, deep-faked versions of athletes from a simple text prompt, is this playbook we just learned even going to be enough? That is the challenge you all will be tackling in your careers.